It's Mike Franklin, a property tax guy, and today we're going to review a small claims assessment review hearing out in the 8th Judicial District in the town of Hamburg that took place via Microsoft Teams with a state hearing officer, Lisa Smith, who's an attorney from the 6th Judicial District, because the 8th Judicial District couldn't come up with any hearing officers, so she had to do the hearing. She has denied me my right to video record the hearing, so I have to do sketches, like back in the olden days before they had video recorders. They claim that I don't have a constitutional right to video record SCAR hearings, and I agree with that. That wasn't written in the First Amendment back in 1791. They didn't have any video recorders in those days, but I do have First Amendment rights, and I believe that they need to substantiate justification if they're going to limit them, but they feel differently. In my opinion, Lisa Smith is violating my constitutional rights, and we'll get into that later. Let's back to the case. So again, the public is allowed to attend these hearings, but the court doesn't want you to record them for some unknown reason. I'm going to suggest it's self-dealing. They don't want to be transparent and accountable about what they're doing. In essence, they're protecting the assessor and the town attorney in the town, and from being transparent to the public as to what they're doing. So, but anyway, so this was a Microsoft Teams meeting. So you could see two people at the top, and the town attorney didn't have the technical capability to figure out how to get on a Teams meeting. It's a court methodology for doing cases, and you would think that an attorney would know how to do that. And the assessor couldn't figure it out either, apparently. And she, I don't think she said a word during this entire hearing. The town attorney did all the talking. And basically, he made zero arguments. All he did was haggle. In other words, the petitioner's representative, the guy on the left there, Steve Filano, he made his arguments. And the town's response is, well, we think our comparables are proper, okay, but they didn't substantiate them. And so on the first case, they stipulated without much resistance. They went back and forth a couple of times, muted themselves and had a little chat, and they stipulated. On the second case, they went back and forth, muting on the phone, with the attorney and the assessor talking for 40 minutes, while the hearing officer and the petitioner's representative sat there twiddling their thumbs. And so the problem I have with this is the assessor should have negotiated this without getting the town attorney involved, without getting the court involved. And so what I'm suggesting is she didn't do her job. And so the taxpayers have to absorb the cost of that attorney participating in this case. And of course, the attorney knows nothing about this case. And so it's just a monumental waste of taxpayers' money. She didn't do her job. She didn't negotiate with the taxpayer in good faith prior to this hearing, which necessitated the court wasting their time, the town attorney wasting their time, the taxpayer having to hire a representative to represent them. It's just improper. So what more do we have to say here? Yeah, they went back and forth, and then the petitioner recommended an assessment of $108,000, which would equate to $351,000 fair market value. So they go back and talk about it for about 15 minutes, and they come back and say, "We'll agree to that if you allow the assessor into your house for next year." And and apparently they think that this is Russia, that they can come into people's houses. And but the petitioner's response was great. He says, if the taxpayer if he's going to be doing improvements, he'll pull building permits, and the town will know at that time. And also, he wants to be treated like all the other taxpayers, because the properties that the assessor is using as comparables, the assessor didn't go on the inside of those houses to verify their inventory in their condition. So he wasn't going to allow that to happen. So they went back and forth, like I said, for about 40 minutes, and they ended up at 120, which came out to 393. And I think it's kind of ridiculous that he would have to get off his number of 108,000, because that was calculated from the recent purchase price with an equalization adjustment for the next year. And I don't know how much more accurate you can get than that. And the assessor had no argument whatsoever. But since the hearing officer, or since the petitioner's representative has no idea what this attorney, who probably has zero evaluation experience as a hearing officer, he has no idea what she's going to do. So he negotiates it to 120. I'm not certain what I would have done in that situation. I'd probably let her do her job, but you got to act in your client's best interest, and I don't know, I guess go with the probabilities. But when you have no idea what the qualifications and valuation that the hearing officer has, you're just pissing in the wind, basically. What more is there to say about all this? It's just outrageous that they wasted the court's time, and the taxpayer's representative and the town had to pay for the attorney for this utter nonsense. What the assessor's job is, when a taxpayer has a concern, the assessor's job is to respond to them promptly, look into their concerns in good faith, and either make an adjustment or politely point them to their appeal options. So, she didn't do that. So you got to get a lawyer involved, and you got to get the court involved. It's just, she didn't do her job. And the whole thing was a monumental waste of taxpayer money, which is why these things need to be video recorded, so you don't have to just take my word for it and my head scratch. We should have this thing video recorded so the public can see for themselves, so that that I don't exaggerate, under or over exaggerate what actually transpired. If the public should be entitled to the facts. So maybe I exaggerated in this case a little bit. If you look at the Lisa Smith hearing officer, I put a little devil's tail on her, because she violated my constitutional rights, and I tell you, there was a war fought to gain us these constitutional rights, and the 6th Judicial District is rather flippant about denying those rights without providing a proper justification. But again, this hearing should never have happened. The assessor didn't do her job, and the attorneys doesn't even know what's going on, and so they settled the case. Did it come out fair and reasonable? I don't know. It should have come out fair and reasonable without the expenditure of the attorney in the court. This is Mike Franklin, the Property Tax Guy.